not allowing me to talk. I think most of you are here to see what our special guest has to say. But before we get to that, we are going to introduce the rest of our panel. Of course, I'm Kathy Gobin. You see me regularly on our Lunch and Learns. Jeremy Miller is here. He is navigating our people that are joining us, letting them into the meet, as well as he'll be letting us know what questions you have. And we really want this session today to be a question answer session, because we have Julie here as a resource, and she is open to taking on the fly questions to see what she can answer for you with any questions today. So keep that in mind. And Greg Simmons is joining us as well, and he's going to be providing a little information about Julie as well. Before we move on, we have to say thank you to our platinum partners, 5-Star, CrowdStrike, CDW, Matrix Integration, and Parent Square. And CrowdStrike's going to share a little bit with us in a moment. If you have not registered yet for the clinic, it is just around the corner. In fact, it is literally 2 weeks away. Mm-hmm. And I just can't even believe that, because I know what all we're working on. But if you haven't registered, make sure you get registered. May 1st and 2nd, new location, the Embassy Suites in Noblesville. We visited last week, kind of run through everything again. And it's a fantastic location. I'm really excited about it. So make sure you get registered. As a reminder, if you are a COSIN member, your registration for one person in your organization is included with that membership. So no additional cost to send someone. So keep that in mind. And now I'm going to throw it to Mike from CrowdStrike to just give us a little bit of what he's brought to the table today. So go right ahead, Mike.
Awesome. Thank you, Cassie. Good morning, everyone. It's a pleasure to see all of you here, and very excited to see everyone in a couple of weeks. Like Cassie said, it's hard to believe it coming up to May. It's already there. But thank you again for having us and do a quick speaking slot here. But primarily, I just wanted to make sure that we get the word out, obviously, when it comes to doing enablement sessions. If you don't mind, Cassie, going to the next page. So most importantly, I wanted to make sure I get the roster contact info here, and I'm hoping, Cassie, this gets delivered to everybody attending the call afterwards. But essentially, this is the roster contact information. As you see, I have myself there with my cell phone number, email addresses as well. I've also included my director, Zach Foss. Important to be, in contact with him as well, because he also works directly with the state, right? For most of you that are a part of that state of Indiana MDR program. And then Eddie De La Cruz is my new SE as of February of this year. We did a realignment, and Eddie and I are now aligned. He's supporting me from a technical perspective. Next page. And primarily, folks, the reason why I wanted to do this again today is to promote more of an engagement, right? Please contact me directly if you can. I know it's hard with everybody's schedules, everybody doing a ton of things on a daily basis. But if you have at least 30 to 60 minutes to spare, we want to make sure that now you have this awesome tool in Falcon Complete, that you have the ability to fully maximize and fully enabled to operate the tools within Falcon Complete. And they're really, really powerful tools, right? And this is something that Eddie and I have done several enablement sessions already. And the feedback that we've gotten so far has been remarkable at how much they've actually gotten to know what the platform can do. So please let me know. And, I'll also be sending out emails as well just to see if we can schedule an enablement session for you and your team. And if in case you are not in the state of Indiana program, there are still possibilities for you to join as well. And if you are not interested in joining it, but interested in learning more about CrowdStrike, by all means, please, we would love to have you and give you more in-depth info around what the platform does and what our MDR entails. But outside of that, I know I've got probably coming up to my 2 minutes, Cassie. So quick shameless plug-in. We will be hosting a 30-minute session at the CTO Summit. I don't know what time slot we have yet, but I encourage everybody to attend, because at that session, I'm going to have Eddie point out a couple of really, really important items that we think you should be aware of when it comes to the tools that's available to you on Falcon Complete. I know it's only a 30-minute time, but I think that would be a great setup for us to reconvene on a one-on-one basis down the road, and again, do that enablement session. But outside of that, that's all I had. Thank you again very much. It's great to see a lot of familiar faces here, and looking forward to seeing you in a couple of weeks. Thank you, Cassie.
Thanks, Mike. I was trying to multitask and look up what time your session was, and I wasn't fast enough because it's embedded in folders, but we are sending out the schedule link on Friday. So everyone will, can check it out then and see where that time slot is. Okay. So let's head on over, and I'm going to throw it to Greg, who's going to introduce our special guest.
Yes. Thank you, Cassie. Thank you, Mike. Allow me to introduce Julie Slavens. So Julie is the ISBA Senior Counsel. She's also the Director of Policy Services for them as well. Julie Slavens, she joined the Indiana School Boards Association staff back in April of 1991. Her responsibilities includes review of board policies and school corporation policy manuals, legal analysis of policies, aid the local school boards in developing and updating current policies and manuals, and overseeing the ISBA comprehensive policy management services. In addition, she also consults on general legal issues related to education, school board issues, and state and federal employment laws and regulations. Ms. Slavens has nearly 40 years of experience in labor, employment, and education law. She received her undergraduate degree in industrial management from Purdue University in 1983 and her Juris Doctorate degree from Memphis State University in 1986. She has worked for the law firms of Parrish, Knight, and Beale, and Gallucci, Hopkins, and Tizen in Fort Wayne, Indiana. She also worked for the Fort Wayne Metropolitan Human Rights Commission as its staff attorney for a year, and she is a native of Battleground, Indiana. So without further ado, Ms. Slavens, the floor is yours.
Okay, great. Thank you, Greg, for the introduction. When they asked me to do this and ask for a Vita, I was like, oh gosh, I don't think I've updated my Vita for years. So it caused me to review that and add some things. So thank you. Okay, I'm going to share my screen. Yes, a second here. Okay. This is the lunch and learn. Let me make sure I can. How can I advance it? Okay, Cassie, can you help me with the advancing it?
You should just be able to click on the screen that your actual screen that has your slide presentation.
Oh, okay. Okay. Okay, the only thing is now I can't see you guys, but that's all right. So one of the topics, excuse me, that I wanted to talk to you guys about today is something that's coming up. Some of you guys may already be have this done because you've been live streaming your school board meetings since COVID. or some of you may still be working on it and tweaking it to not, well, I should say perfect it, but to make it better screening given what the statute requires. So the statute is in the open door law in Indiana Code 5-14-1.5-2.9. And basically what this law requires beginning July 1 of 2025, so just coming up here in 3 months, is that you are to provide on a publicly accessible platform, and it's the board's choice. You know, you can use Zoom, you could use YouTube, you know, whatever's out there, to live stream the transmission of all the board meetings, excluding executive sessions. Now, this does mean all of your board meetings that are open to the public. So that would be your public hearings. So like your if you have your budget hearings separate from your regular meetings, it would include those hearings. It would include your public hearing on the superintendent's contract, those kinds of things. And also work sessions that the board has that would also include those. The other thing that the statute requires is that that copies of the live transmissions, copies of the recordings be archived. And the archive has to include links that will send the person to the meeting's agenda, minutes, and any memorandum that you might have, or any records that you might have with respect to the meetings. And then also it states it requires that the meeting notices must contain the website for your live transmissions and the archived copies. Now, in some areas of the state, there may not be internet capability to do this. So you would have to record and retain the copies of the meetings. And the archive requirements would be the same as for your live transmission. So you'd have to archive them. You'd have to include meeting agendas, minutes, and memorandums in those recordings as well. So then it also requires that these copies are available for at least 90 days after the date of the meeting. And these have to be archived on the school corporation's website. The availability also means that a public can be able to inspect the meeting recording or transmission, to copy it and or to download it. Now, it does provide that you may charge a fee to copy or download the transmission or the recording of a meeting, but you do not have to. That is at the school board's discretion to do that. The archived copies of the meeting may be destroyed after 90 days. So you have to leave it up and available at least 90 days after the date of the meeting. You can choose to keep those longer, but you don't have to. The statute requires at least a minimum of 90 days, or at least have them available after 90 days. But it may not be available on the website, but maybe you have a file where you keep them, and if somebody makes a request for them, you would have that available to send to them. One of the things that the statute does provide for, which I was very happy to see this, is that if for some reason you have a technological failure that disrupts or prevents you from live streaming or recording or archiving or maintaining a copy of the transmission or recording, it doesn't violate the law. And it doesn't prevent the board from continuing the meeting. It doesn't invalidate any action that the board takes at the meeting, and it doesn't subject any person to civil or criminal liability. I think the General Assembly understands that there are times where transmission just isn't possible. We have storms, we have, just cable going out or whatever that, or the internet going out. So that, so they did provide they did provide for that those occurrences, and still allows you to go ahead with the meetings. You don't have to stop the meetings just because you cannot continue recording the meeting. So again, that is required as of July 1, 2025. This law was passed, I believe it was passed 2 years ago. So we've had some time to look at this and prepare for it, but just wanted to put that on the radar. I'm sure you guys have all looking at that, but wanted to give you just the information of what you have to do once you do record the meetings. So.
And Julie, there is a question about is there a specification of video versus audio in the Indiana code? Audio only is an option. Does that satisfy the statute?
That's a very good question. I believe you have, well, you would definitely have to have audio, because the point is so that people could hear what's going on. So like, I know sometimes in technological failure, the camera may not work, but you do have audio. So I think that would be okay. I'm going to get to the statute here real quickly. I think it just says recording. I'm not sure that it distinguishes between the two, but sometimes it does. Just give me a second here. Oh. Okay. I'm looking in the book at that. That isn't in the book. So let me go online. But I think that the issue is to be able to live stream the meeting so that people who can't make it to the meeting may see it, may watch it. So I think you at least need to have audio on, audio availability. I'm not sure that video is crucial. I think more the audio would be crucial. Okay. Because the point is so that people can see the business of the corporation when they're not able to personally attend. So to me, audio will be correct, but I will, my recollection in reading the statute is that it doesn't mention the difference or what, but just the public policy of the statute, the open door anyway, is for the public to be able to know what the government is doing. And so that would be, to me, that would be more, the audio would be more important than the video. Okay.
Perfect. Thank you.
And again, this does apply to other agencies. It's not just school corporations. Okay. Any other questions on that topic? And if you think of others later, I'll be happy to answer those. But the next topic I want to talk about is.
I'm sorry. This is Patricia from Marion. I do actually have a related question, real quick.
Okay.
You mentioned the memoranda. I'm just trying to clarify what that means. Is that referring to like the full public record of documents that are provided to the board has to be linked to that archive? Or is that something that still requires someone to request to view as a public record?
Memorandum. Okay, but yeah, very good question, Patricia. Memorandum in the open door law is often linked to minutes. Sometimes they use minutes and memoranda interchangeably. Like in the statute that requires minutes of the meeting, it also says minutes or memorandum. I'm not sure what the difference is, but so they just repeated that same language in the in this statute. So I think it's however you refer to your minutes of the meeting.
Great, thank
So
you.
remember, yeah. So now obviously the agenda may have some links to supporting documents, but it doesn't have to. That's not required by the statute. But the documents that are not confidential at the board meeting, obviously are subject to a public records request, which you would have to give if members of the public ask for that. But I don't read the statute to require you to have those links to those documents available on the meeting minutes or the transmission, the recording of the meetings. Okay. Good questions, guys. Okay, so I'm going to talk a little bit now about FERPA. And you guys are probably going, well, why do you want to talk about this? It's student records. Well, you know, a lot of things dealing with students are now electronically stored. So there are some issues that I just want you to be aware of with respect to FERPA and your SIS. So just as a basic requirement, anything that the school maintains, any information, any documents, any records that the student maintains, that the school maintains about a student that is enrolled in the school is an educational record under FERPA. And FERPA is a federal statute. It stands for Family Education Records Privacy Act. I use FERPA so much I have to stop and think what FERPA stands for. So this basically is a federal law that deals with student records. So FERPA basically said, the basic rule of FERPA is all educational records are confidential. Okay, so you cannot disclose them without parental consent. Okay, but FERPA is like English. You know, we have a rule for English, but there's also exceptions. You know, I before E, except for after C. I mean, we have all kinds of exceptions in our English language rules, and FERPA is the same way. So one of the exceptions is that any school employee or a contractor who has a legitimate educational interest in a student record, of information in a student record, can see that record without having parental permission. But you have to be careful, and this is kind of where it comes in with respect to your student records systems, is that they only have a right to see the portion of the records that they have a legitimate educational interest in. And so I put on the screen here, like, so if discipline, you know, if the expulsion examiner for some reason needs to review the discipline record of the student, they would have a right to do that, but they necessarily don't have, I mean, they would have a legitimate educational interest in reviewing that, but they wouldn't necessarily have an educational interest in reviewing the grades. Okay, so there may be sometimes you just give permission with respect to discipline actions that have been taken against a student. On that topic too, so if a student is in third grade, teachers that have not been assigned to that student in third grade don't really have a legitimate educational interest in the student's records. Okay, there may be some rare cases where maybe they do need to look back in second grade to see how the student did on some testing or specific language or math concepts, and maybe the teacher that the student had is no longer there, but that information is in the employee, or excuse me, in the student record. That would be a legitimate educational interest for the teacher to see that part of the record. But they would not have, so a sixth grade teacher would not have the right to see a current third grade teacher's or a current third grader's educational record. So again, you have to be cognizant of that, of what access you give to what teachers with respect to individual student records. One time, this has been years ago, I gave a presentation on this about FERPA records and talked about this aspect of it, the legitimate educational interest. And afterwards, the IT director for the corporation came up to me and said, Julie, when I took this job 2 years ago, everybody had access to all student records. And I just went, I'm like, no. He goes, yeah, I know. I'm working on fixing that. So that just be aware of that. Then another, so I also want to talk about contractors a little bit. I mean, sometimes now we do have third-party contractors who are who are storing the student records and all that, you need to be sure that those contractors understand those records are confidential. And when they are working on behalf of the school corporation with respect to those records, they are an agent of the school corporation. And under FERPA, they are subject to the FERPA regulations. So the same rules that would apply to the employees that I just spoke about would also apply to those contractors and the contractors' employees. So keep that in mind and be sure that that is addressed in any MOU or contract that you have with those third-party contractors. Then the other exception is directory information. FERPA allows a school corporation to define directory information, and basically this information is information that's not personally identifiable to the student. It would include like name, address, date of enrollment, date that they withdrew or date they graduated. It does not include their attendance record, their daily attendance record. It does not include their discipline record. It does not include their grades. It may include their height and weight for athletic purposes. It could include honor roll or academic awards that they've received. But the statute allows the school to define directory information. The school doesn't have to define directory information. So the easiest thing is if the school doesn't have a definition of directory information, no school records are to be released without parental consent. Now that can make it difficult sometimes for your sports teams, but that is the easiest way to do it. Usually, I mean, at ISBA, we have a sample policy of directory information. I generally just say, yeah, the child's name and address. You can also include the email address, but only if it's a school domain address. So not their private or personal email address should be on directory information. So what FERPA says is the school can define that, and at the beginning of each school year, they have to provide that information to the parent and give the parent a reasonable amount of time, generally 20 days, 30 days, to review that information and decide whether they do not want any of the directory information disclosed. They could choose all of it. They could choose 1 or 2 items, and then they tell the school that. And so then the school will have to be cognizant of what directory information the parent does not want released. So again, that may be something that is electronically stored in your student information system. So be aware of that there has to be a way to notify them of that. And I think a lot of times the student information systems do have ways that all this can be done online by the parents, and they will be able to fill out this information and that kind of thing.
Julie, if I may interrupt just for a moment, a question that came up. So we notify parents or guardians of FERPA directory information in the annual registration. Does the school need to have a yes, I agree back from the parents, or just simply notify and then it's on the parents to get back to the school if they want something different?
Right. Basically what FERPA says is directory information can be disclosed without parental consent unless the parent says, no, I do not want that information disclosed. Okay. So it really is on the parent. But I have seen some forms, and I think even the ISBA sample form that we put out, we do have a check mark that says, yes, I agree that this information can be disclosed without my consent. But you don't necessarily have to do it that way. But FERPA requires that the parent tell the school corporation what information and directory information they do not want released without their consent. And again, it could be the entire definition, because like I said, sometimes there's 4, 5, 6, 7 items. They could choose what item they want, or they could say all of the items we don't want disclosed without our consent. Okay.
Thank you.
Thank you. Great question. I was looking at my notes to see if there's anything else I want to talk about on that. So that's basically, I think, I mean, I could talk a lot about FERPA, but I think from a technology standpoint, that's the basic information that you will need to know. That's not what I want. There we go. It's skipped. So I also said I'd talk about some AI issues. And when I started preparing for this, I was like, I don't know why I said this, but because I'm still trying to wrap my head around AI issues. I mean, I've taken some of the courses that the Learning Lab has, not courses, but webinars that the Learning Lab has put out, and they've been very good, but I'm still not sure how schools should be doing this, or what schools are doing and all that. But from a legal standpoint, one of the anything new comes along, it takes a while for issues to get through the courts and get us answers on that. I mean, we went through that a lot with emails. Is email a telephone call, or is it a letter, or that kind of thing. So I mean, we're really still seeing the law develop on this issue. State laws, federal laws, and even cases in the courts haven't really been that prolific yet about use of AI in schools or in society in general. I believe last year, Indiana did pass a law that set up a commission on looking at AI issues, but I don't know that anything specifically has come of that. So the issue then becomes that schools basically can do what they want with respect to AI. I know when it first came out, some schools were saying, no, we're not going to use it at all, but that quickly went away because kids were using it, long before schools probably knew about it. So I think it behooves you just to see what your schools say, either through policy or through procedures on the use of AI. I know that some corporations are just looking at the use of AI with respect to teachers using AI to teach in the classroom, but some are also looking at use by students. Some are allowing teachers to determine how students are going to use AI in their classrooms. Some have said, they're only going to allow AI use, for 8th grade and above, or high school. And some are letting all grades. So it's going to be all over the board, I think, as this all evolves. I will say, obviously, I think the biggest issue that we have with AI is, one, cheating, and two, plagiarizing. And I guess there's three, and three, referencing AI. Back, I'm going to age. Well, you guys all know how old I am now. So anyway, I mean, back in my time, we had the bibliography, we went to the encyclopedia, we went to books and all that. We knew where our sources were from. With AI, we know we got it at AI, but sometimes AI doesn't always tell you the source. Sometimes they do. So how is that? How are we going to mean to codify that where, this source was an AI source? And then also the issue is making sure it's valid information. I will have to go back. There was a case, it wasn't in Indiana, but it was in a federal court where there was a discovery situation when the attorney was not complying with discovery issues, and then her brief was late. Well, the brief that she submitted, she used a case that she found through her AI research. Well, the case didn't exist, and the attorney didn't look up to see if the case was existed. As an attorney, I know there are ways to find if that case exists, and so did the court. And so the court, basically said, yeah, we understand you're using AI for research and that can be a time saver, but when you find something to support your argument, you need to verify that case actually exists. So there are those kinds of things. So I guess the issue there then is how can you as IT people help with determining if there's been violations of policy, or cheating or plagiarism, etc. Again, it's not an issue that's going to go away. It's here to stay. So we have to figure it out. I think, as with a lot of things, a law is going to be behind the use of it. And, we may see laws or court cases, in the near future addressing some of these issues, but there's just not a whole lot out there yet that's definitive. So we are grappling with the appropriate use of AI in various as areas of education and the world, basically. One of the things I did through the Learning Lab, I did watch one webinar on the use of AI in schools by students, and there were 4 or 5 students from around the country who spoke, and they were great kids, and they talked about how they use it and all that. But I mean, one of the first things they said was, it shouldn't be used to cheat. It should be used to help you, research, help you with grammar, help you with writing, appropriate, syntax and all that kind of thing. So they saw it more as an aid to helping them with their assignments rather than using it as cheating in that. So that kind of warmed my heart that they were aware that that issue is out there and addressing it. So any questions on AI? Again, you guys probably know more about this than I do because there's just no law on it. It's more, these are just issues of really schools locally can address the use of it within policies or procedures.
Yeah, and there are no questions coming up in the chat at the moment. So,
okay, good. I'm glad to hear that. So the next thing I want to talk about is some bills that I think you guys wanted me to talk about 472 a little bit, and there's one other one that may be addressed. There's not a whole lot of other bills yet that were that deal with technology issues, so to speak. But I do want to talk about 472. I will tell you what the status of it is right now. It has been gone through both the Senate and the House. The House made some amendments to the original bill that came out of the Senate. There has been a concurrence filed that was filed yesterday, and it is scheduled to be voted on by the Senate today at this afternoon. The Senate right now is scheduled to come in at 1:30, and this bill is on the docket to be voted on the concurrence. So pretty soon this will be passed by the General Assembly and go to the governor's desk. So basically what this bill does is it requires the Office of Technology for the state to develop standards and guidelines regarding cybersecurity for use by political subdivisions. So it's not just going to be about school corporations. It's going to be all the other local entities that make up political subdivisions, cities, counties, commissions, that kind of thing. The bill also provides that they do the same thing for state agencies. So it's pretty broad that these standards and guidelines are going to be applicable basically to all governmental entities in the state. The bill also says that all school corporations are to adopt no later than the end of 2027 a technology resource policy and a cybersecurity policy that meets specific requirements. And those are set out in the statute as well, at least for the technology resources. That policy is supposed to prohibit you from engaging in using it to engage, using the technology resources to engage in lobbying, engage in legal activity, or to violate the cybersecurity policy. And again, it's also to include disciplinary procedures. But later on, the bill talks about that the school corporations are to develop, are to adopt the policies that are going to be developed by the Office of Technology and the Department of Education on uniform technology resource policies and a uniform cybersecurity policy. So all school corporations will have the same policy. So on both of these topics. So once those are developed, I will try and get a copy of those and then send them out to school corporations in the state. I'm sure the Department of Ed will also be doing that. So we're going to have a little over 2 years to do that. I don't know the time. I mean, I don't anticipate that will be done by the end of this year, but hopefully sometime in 2026, so that it gives school corporations the opportunity to review them and adopt them. Because the statute says we have to adopt the uniform policies that the Department of Ed and the Office of Technology put out, I don't think we're going to have an opportunity to change any of the provisions unless in their sample policies they give us options as to what you can choose to do. A lot of times, though, the ones that I have seen state agencies develop, there's not a lot of options. So that will be coming down the pike here in 2 years. So if you currently have a cybersecurity policy or a technology resource use policy, it may comply with the uniform one that's coming out, or it may not, but you will have to adopt a uniform policy unless this bill gets changed in 2 years, but before December 31st, 2027. It also says that a public entity, which includes a school corporation, that you are going to submit every 2 years your cybersecurity policy that the school board has adopted. If you're adopting a uniform one, I don't know why they're having you submit it. I guess they just want to be sure you are adopting their uniform policy. That may also indicate that, although the bill does not really say this, that the office will be tweaking their policy, their uniform policy, at least every 2 years. So that may be indicating that we are going to see some changes, which I am sure we will, because there's going to be, technology is changing all the time, and so I'm assuming there will be changes to these uniform ones, even though the statute does not say they have to do it every 2 years, but I'm assuming they will, or we will have revisions of these policies coming out every so often. Then the last one requirement of this statute says that if you engage a third party to conduct an assessment of your cybersecurity policy, you have to provide the results of that assessment to the office. So it sounds like you might have some, even though they're giving you a uniform cybersecurity policy, there may be some more options in their cybersecurity policy that the state puts out. So we'll just have to wait and see what they come up with on that. Any questions?
Yeah, Julie, one question with 472, it says public entity. So is the spirit of this Senate bill that it would only pertain to public schools, or are charters and privates included in this?
That's the definition of public entity in the bill just as a political subdivision, state agency, school corporation, or state educational institute. So it definitely does not include private schools. Okay. Although nothing would stop the private school from adopting these two policies that come out. Trying to think of the definition of political subdivision, if that includes charter schools. It may, because I think that talks about someone who has, well, it may not, because I don't know that you guys have, I don't know that charter schools have taxing authority. So it definitely would apply to school corporations.
Okay.
And then up in the air, which I don't know why. Charter schools are public schools, so I don't know why they wouldn't include them, but maybe at some time they will add them, and then I will just need to double check on the definition of political subdivision to see if that includes charters, because I have not looked at that, and quite frankly, I work for the School Boards Association. Charter schools are not a member, so I don't really focus on what charter schools do. So I'm going to make a note of that, and what I'll do, I will look those up and I will send those to you, Jeremy or Casey, and then you can pass that along to the members or the people who are on this webinar. And then what was the other one I was going to look up? Oh, the video on the
audio video.
Yeah.
So one other question that popped up here.
Sure.
Have they yet notified or stated what kind of a reporting avenue they might adopt for this Senate bill?
That's a good question. The bill requires the office to come up with the methodology for reporting whether you've adopted these policies or submitting the policies. So the bill requires the Office of Technology to do that. Now, I have not heard what they're going to be doing on that, because they have 2 years. So I think, so it could be that the Department of Ed may collect the ones that that school corporations do, and then pass those along, to the state agency, to the Office of Technology, or it may just be the Office of Technology sets up a repository and sends that to the department, and the department will send that out to school corporations. So no, I've not heard any details on that yet. So stay tuned on that.
Just as an aside, during your last 5 minutes of talking here, I literally received an email from DataServe that was discussing Senate Bill 472. So if anybody gets those emails, check your inbox for that.
Okay. Alrighty. Oh, also, and this is already in law, but I just also want to point out that when you adopt these policies, the cybersecurity policy and or the technology resource policy, there is a training requirement for the public entity to train their employees on what these policies require and what they can and cannot do under the policy. So also keep that in mind as well. Okay. So like I said, I don't anticipate these policies being done this year. But we probably would have something in early 2026. So. Okay. And then, we're right at one. The other one I just want to talk about real quickly. This probably is going to be tangentially affect you guys. 1498 is a school accountability bill that was amended and it has been returned to the House. It is a Department of Education bill, so I don't think it's, I think there probably will be a concurrence filed on it. It just hasn't happened yet. Basically what this is, it repeals the old accountability or assessment program, and requires the State Board of Education to establish a new methodology. I know right after the new diploma requirements were done, Katie Jenner announced at the State Board of Education meeting, the next thing the department is going to do is work on this new assessment program. So it is coming. We're still going to have the A to F reports or grades. And I think basically what the plan is that this new accountability will be more tied to the dashboard and information that the dashboard has. So like graduation rates, attendance, again, obviously I learn, I read scores, or maybe even other assessment scores that schools are using. So it's going to take in more data points. It does extend to 2027, the reporting requirements. And, those are the reporting requirements of that we currently have to do, including the scores on, DOE sends you this information and you're required to post this information, your scores on assessment, graduation rates, attendance rates, those things that are required in 20-19 is that's just going to extend to 27 because it's going to take a little bit for the board to review these regulations because they have to be written and then posted in comment period, and then the board will approve them. I think they're planning to get that done by the end of this 2025, but it may take them a little bit longer to do that. So I don't know that this technology-wise this will change much, but with the new assessment scores and with the dashboards and all that, there just may be some new reporting requirements or systems that you might have to install relating to this. Don't know that, but just wanted to let you know that. So the fourth bullet point there at the top provides that the diploma waivers may be eliminated. I mean, I'm not sure that is relevant to you as in your jobs as technology, but just an FYI, because I know your systems may already address that, so that may be going away as well. But that is something that again DOE would be addressing and proposing. So that I know we're a little after 2, but we did get started a little late. So this is my contact information that you can use to either email me or call me. If you have any other questions about the information I gave you or any other technology related issues. So just I'll wrap up there. And I thank you for attending. And I don't know, are there any more questions?
Again, nothing in the chat at this point in time. So
Great. Well, thank you.
Thank you, Julie, so much. Thanks to everybody for being flexible and for making it work and hopping on this. We did record everything, and we're still going to make sure it gets posted to our YouTube channel. So if you want to share this link once that gets posted, I can plan to send out an email to everybody who registered for this event with that link whenever it goes live as well. Okay, just as a reminder, if you haven't signed up or registered for the clinic, that is going to be May 1st and 2nd. And we should be sending out the schedule so you can see more about what the sessions are that are happening and the events that are going on for that. Thanks again to Mike and CrowdStrike for being part of today, and have a great afternoon. We'll see you all soon.